Hi there, and welcome to HR Live. One of the first steps for the majority of new on-demand HR members is to undertake a comprehensive workplace relations review and structural implementation. We often get asked if this process is really necessary for my business, as my business is different for a whole number of reasons. So today we're going to take you behind the scenes and introduce you to one of On-Demand HR's senior consultants to share why this first step is so essential, and to share with you our process and what to expect when you go through our workplace relations review. HR Live, of course, is the weekly live show where we take a HR or workplace relations challenge that is impacting business. We unpack it and we offer some tips, tricks, and strategies that businesses can adopt in order to navigate through. My name's Andrew Kalita. I'm the Operations Director of On-Demand HR. And since 2010, we've been helping businesses of all sizes to navigate through Australia's complex industrial relations system. Throughout this time, we've appeared in more than 120 matters before the Fair Work Commission and other bodies. And it's really this practical experience that goes well beyond theory that allows us to offer advice and insights that balance risk against the interest of the business. And this ultimately leads to decisions and outcomes that are in line with the business's objectives and not simply based on mitigating risk. HR Live is also a great opportunity for you to put forward any questions around HR or workplace relations that your business is facing. And if we can, we'll try to answer them live on the stream. However, if there's a bit more to unpack, we'll cover this topic in a future session. Or alternatively, we also will give you an opportunity to schedule a free HR consultation supported by a strategic action plan with one of our experienced HR consultants. So with that all out of the way, please let me introduce one of our senior HR consultants, Jason Norrie. Jason spent more than a decade in the HR and workplace relations space, working with businesses of all sizes, providing strategic advice and support that's aligned with the business interests. At On-Demand HR, one of his functions is our award guru. And I'm not even joking here. When it comes to award coverage and classifications, the entire team, including our managing director, Clinton Drell, listen very closely to what Jason has to say. So we're very lucky to be able to have him here to pick his brain. Welcome to HR Live, Jason.
Thanks for that, Andrew, and to everyone out there. Yes, at On-Demand HR, I am that technical expert. Awards is just one of the many areas, the complex areas within HR and workplace relations that I love to dig into, just because every business is different. I like getting into the nuts and bolts of a business and ensuring that I can help that business as best as possible to understand how things apply to them in business talk, that is.
Fantastic. So to help us to understand why the workplace relations review is so important, I thought it would be really good for our audience to hear some of the common pushbacks from clients when we recommend a workplace relations review, and to understand your thoughts and insights on how you answer these questions. So kicking things off, by far one of the most common questions or objections we get from clients is that they're saying that they've already had their professional advisor, such as their lawyer or their accountant, to look at their employment contracts and other documentation in the past. So based on this, they ask us why they should pay someone like On-Demand HR to do it all over again. Do you have any thoughts or insights on this?
Yeah, good question, Andrew. In my view, generalist lawyers and accountants do not have the specialized knowledge in the HR and employment contracts sort of space. And in their profession, they do not work with the mechanics on a daily basis. They have other competing priorities that are more aligned with their profession. So they may not put meticulous detail into supporting the business in the way that we do when working directly in the specialist space. I would ask any business about their contracts and how long it's been since they've last reviewed them. In the last so many years of the employment relations legislations, we've had the most amount of changes just within the last 2 years alone in this sort of space. So I would ask, are their documents up to date? When were they last looked at? And is there anything irrelevant in those contracts, or are they hard to understand and read with a lot of jargon that your employees wouldn't understand? Ultimately, it's about ensuring that these documents suit the business's best interests, that they're easy to understand for their employees, so that when they're needed and called upon, they can be easily understood.
Yeah, I think that's a really good point around, I guess, inclusions of clauses and in the employment contract that are not necessary. And quite often, I don't know what your thoughts are on this, but we see, particularly lawyers, if I'm honest with you, that don't have that specialized knowledge, they include a lot of additional clauses that create some additional obligations on the business. For example, putting policies and procedures clauses inside employment contracts. Why do you think that that's a problem?
Well, when it comes down to the employment contract, you want it to be securing the employee to work for the business. That's basically what the contract is. It's about the mechanics of master servant, basically the engagement to the business. But if it's restrictive on the business's way in which it operates, it's going to obviously make operations harder when they need to change policies that are in their contracts. If the contract says that it's got to be done a certain way or a certain step, this policy or procedures in place, then the business can't change it unless the employee unilaterally agrees to change what's in their contract. Alternatively, if a business was to change things and not consult the employee, they could be themselves breaching their own workplace standards, and again could bring further difficulties to the business in trying to repair something that could have been easily sought after if it was in a handbook or a policy manual, so to say, rather than a contract itself.
Fantastic. I think next, I want to understand, we often get asked why they need to undertake a workplace relations review if they're already paying their staff well, and in their view, importantly, they're paying their staff significantly above the award. What do you say when clients put this to you?
Well, when they say that they're paying significantly above the award, it's the first thing that always comes to my mind, and always thinking in the background in my head when I meet new businesses is what award applies? What award or legislation are they basing their business or their judgments on? And are they up to date with the most common changes within that award? Then again, you could also look at, is the figure based off the correct classifications? An incorrect classification, such as in the SHADS award, could lead to a huge difference in the minimum wage that an employee is entitled to. And again, you've got awards that have annualized salary requirements. So it's ensuring that those annualized salary requirements are also kept up to date, not only just saying that they're above award and they don't have to apply them.
Yeah, I think that's a really good point. It's when it comes to pay rates and making sure that employees are being paid correctly, there's a lot more involved than, I guess, the headline rate of pay. Things like the annualized salary arrangements, things like penalties and allowances. And I think that when it comes to award classification, quite often businesses might have, for example, a occupational award that they believe applies to their employees, but they forget that they might also be covered by an industry-based award. Do you want to tell us about the common some common mistakes, for example, maybe in the IT industry, that businesses make this mistake?
Yeah, so the awards have a hierarchy of how you should apply them, and it's usually industry over occupational. There are some occupational awards that do trump industry awards. You've got to really know these quirks from precedent cases about how they could be fitting into either category. A very common saying within the awards, it's about the environment in which the employee works in that's most suited to their position of what they do. And that's where, again, when it comes to specifically IT employees, you've got to be in the environment of an IT business that's providing IT services for you to apply the Professional Employees Award. You could have an IT professional in a HR business like ours, and the award wouldn't cover them because the business isn't delivering those IT services. So then you're looking at award free or miscellaneous. It could be Clark's Award as well, depending on the level or the nature of the role that the person does. It comes down to personal attributes such as their qualifications. It's about whether or not they're recognised as an IT specialist to hit a few exemption clauses in miscellaneous award. And it's not only about the business, first and foremost, it's about the whole combined overview picture of the business, the industry, your services, the person's role, qualifications and experiences they have that help sum up the award coverage for that individual. And it's a perspective view on putting all of those pieces together and ensuring that you apply them in a plain sort of knowledge that's easy to understand by others.
I think the IT award and the example that you just gave is a really good way of I don't know, highlighting how complex this is, and but not only complexity, that complexity leads to how easy it is to make a mistake when it comes to award coverage. I mean, I know the kinds of conversations that we have during our weekly team meetings, and you know, just to share with the audience, sometimes it can get quite heated around award coverage, trying to find the right solution for the business. But one thing that always comes to mind is Clint often uses the saying that you don't get to choose the award chooses you. And that's where businesses need, I guess, to either for themselves to invest the time to understand the award system and what award might cover some or all of their employees. And I think that's the other important point. You know, one award does not necessarily cover the entirety of a business. Different employees within the same business might be covered by different awards, and they either need to invest the time to understand this themselves, or again, that's the point around the workplace relations review. Next one I wanted to talk to you about is we've spoken to clients who have previously undertaken a similar process in the past and feel like their workplace relations review, no matter how comprehensive it was done, and it may have been done by a specialized HR person, but they feel like it's a set and forget project. Once it's done, that's it. I can forget about it forever. But as I understand it, legislation and modern awards are constantly changing. And with the awards, there were some big changes beginning in 2020, which I understand are still taking place today. Do you have any insights that you can share on that?
Well, yeah, the modern awards, when they were made in 2010, were actually meant to go through a full yearly updating process. They realised how big of a task that was at the first 4-year stage, and they didn't actually release their first major updates until the 2020 period. They've scrapped the 4-year update model. They're slowly working through the majority of the awards. Most of them have the 2020 title on them at the moment. You may find a few small ones out there still, such as Hair and Beauty, which is 2010. But it doesn't mean that these awards won't get an update or haven't had updates. The Fair Work Ombudsman actually, or Fair Work Commission, from precedent cases or applications made to the Commission, update them all the time. So it's one thing to understand that the award that would cover your business now or has traditionally covered your business, but it's something that the businesses should at least review yearly on every financial year, or when they're specifically working with a specific clause, such as meal breaks or how overtime may apply, that they just refresh themselves with that specific clause in the award, because it could have got a mid-year update, or a case or precedent could have pushed through a change through the Fair Work Commission. The SHADS Award had another big update just recently, where they've gone through and changed a lot of mechanics and the way things worked. Tried to put it a lot more into plain English to make it more understandable. A lot of awards recently, the 2020 update also got tables put in them about minimum rates of pay or common allowances throughout the award to make them a lot more clearly identifiable when we have to put all these together for either annualized salary or just common law salary arrangements.
Yeah, and that's a lot of changes. I know the SHADS award is your favourite one to work with. We
not really.
work with a lot of we work with a lot of not-for-profit organisations, and basically, so we're dealing with this award quite often, and it's one of the more challenging ones. The other thing that's
well, I was going to say it's just basically 4 awards all mushed together. So that's what makes it more complex. You've got to understand like which segment of the award are you thinking about and how it applies to the industry that you're in. And I think that's just the most complex piece about it, is that you've got to understand your stream and then which clauses relate to which stream. That's why it's complicated in some cases. Not to mention the classification schedule.
Makes sense. I'm glad it's you, not me, going through that. The other thing that's, I think, has been well reported in the media around change has been there's been some significant changes in regards to the casualisation of the workforce, or how casuals are deal. I guess in the media they're reporting that, you know, as a country, we're becoming a little bit more casualised in terms of our workforce, and associated changes have been made. Do you have anything that you can share around some of the changes that have happened with casual employees and things that businesses need to be aware of that's covered in our workplace relations review?
Well, we've gone through a lot of changes with the casualisation, and when we talk about casualisation, it's basically the government want to secure work for Australians as best as possible. They always look at that unemployment rate, and they're trying to secure permanent employment as best as possible. We haven't gone through all of our casual legislation changes. There's wind that there's more coming through with some of the promises the current government has made that they will be trying to have a look at that system again and ensure that it's meeting the needs of Australia as best as possible. It could be rolling back some of the current changes or even implementing new ones. And it's not just for casual workers, it's also going to affect fixed term contracts and successive rolling contracts being back to back. So with that changing space, we just have to look at what the precedents are and ensure that from the current standards and the changes that we went through in the last few years with casuals, that we're putting together the best clauses that are ultimately possible for the business. I was just speaking to a client yesterday about casual loading being one very specific piece and how we record it on pay slips, and whether or not if it's separately identifiable. And if it is, and we can clearly identify how much the casual loading is, and if an employee is ever deemed to not be casual, well, that's a good opportunity there for recourse to be able to recall that if the employee is ever deemed permanent.
I think all of that is a really good advertisement of why a workplace relations review is not simply set and forget. I know with the casual, I guess, changes, just as an example, they've gone from one point from a common law definition to a casual employee across to it being legislated in the Fair Work Act, and now it sounds like potentially the current federal government are looking to change it back. And you know, that's just a really good example why you can't simply put something in place and leave it in place for 10 years and don't look at it again. I think some other businesses are really hesitant to undertake a workplace relations review because they've got a low number of employees, and in some cases, the majority of their workforce are contractors. I know that's something that's been coming up with a lot of our clients very recently. Do you have any advice on experience in terms of the workplace relations review, whether or not it's applicable or going to be suitable for businesses that have a high number of contractors?
Well, the obligations to employment relations exist in all businesses, ensuring that you manage your workforce to the appropriate legislations, not with just contractors, but volunteers, through to anyone else who provides services to the business. The Fair Work Act has a lot of mechanics around it under the heading of sham contracting about whether or not someone is a genuine contractor over through the totality of the relationship and how the businesses interact with each other. Some businesses may have a high control factor within how they operate and could make that person look more like an employee than a genuine contracting relationship. Good business contractors, they're in their own space, operating their own business in a subsect of your business. And it's about that relationship of two businesses owners getting together and making the one product, or is one got an authority or power of the other one, kind of making it look like an employment relationship. And depending on who you go to for advice, they may be only looking at their single side of the story. Accountants may just look at whether or not the ATO for super and things like that look like that they're a worker, whereas the Fair Work Ombudsman's test could come back completely different. What's contractor under one could be an employee under the other, or hopefully they align and they are contractors or they are employees. But the most riskiest thing there is that, well, to ensure that your contractors are contractors and that they're not going to lead to future risks of employment relations or gaining the rights of employment relations, things such as back payment of entitlements and wages, super coverage under workers' compensation, are just some of the sort of key factors. And it's not about the factors at the time of the test. When it comes back to wages, it could be up to 6 years past that they could claim for underpayment of wages or entitlement claims and things like that.
I think our workplace relations review is a lot more than just, I guess, award coverage and pay rates and, you know, contractors, employees, all these sorts of things. The other part of our, or essential part of our workplace relations review is to create or revise policies and procedures, documentation for clients. And often we're told that they may already have a comprehensive manual in place. So in your view, why is it so important to review these, or even to have these types of documents in place in the first place?
Yeah, some people think that policies and procedures are set and forget or rainy day sort of procedures. What you want to do is have a good set of policies and procedures in a business that guide the employee on how to be a good employee. That's basically what it is. What are the good ways in which an employee would conciliate with the business to seek their entitlements? How do they apply for annual leave? What is good performance? What is poor performance? Or what is misconduct in these policies? A business that carries too many policies or complex policies, policies that look like scientifically drafted documents, could become too complex to operate with. Policies that become very rigid and say that you've got to go through multiple steps in order, multiple forms and documents have got to be filled in, could make it too strenuous for a business to go through certain processes when a policy that's drafted to the need of the business, to sort of the environment or the climate that you work in, could be a lot more easier to operate. Traditionally, people think that it's 3 strikes, you're out type of a disciplinary conduct sort of piece. So if your policy says that you have verbal warnings, first warning, seconds and thirds, and final warnings and things like that, you could be potentially keeping your employee a lot longer than you necessarily have to. What we look at when we draft policies for the business is getting to know what is a business's working style with how they relate to their employees. What are some common trends that have been in the business previously about how they conciliate on certain matters? And I sort of pick apart the employer's processes to help understand how should that policy be drafted. Do they need something that's rigid? Do they need something that's got flexibility in it? Do they need certain policies that other businesses wouldn't carry because of the diversity of their employees? A couple of policies I've used recently are cultural leave for some of our clients with the original Australian workforce working for them. They've got a lot more types of leave that would be, their family is not necessarily a direct family. Their culture, their people in their community are their family. So taking bereavement leave for someone in their family who's a respected elder, they would consider that bereavement leave, but we would consider that as annual leave underneath the Fair Work Act. So it's about ensuring that the policies are shaped to include the workforce, that they're to be relevant to the times and can help a business manage through that process with checking off all their obligations under the Fair Work Act or Work Health and Safety Act, whatever it may be.
Yeah, I think my summary of what I understand of what you just covered is policies and procedures are an enablement document to be able to enable the business to carry out their business in the way that they want. But one of the things that we need to be conscious of is we don't want the policies and procedures to be restrictive of the business to carry out the business in the way that they want. And anything that's additional that we're providing to our employees that we're not obligated to potentially can be included in the policies and procedures document, such as the bereavement leave that you mentioned. And one of the reasons why we aim to do this in a policies and procedures manual as opposed to an employment contract is, again, a policies and procedure manual can be amended by the business without mutual agreement by the employee. So again, it's about maintaining that flexibility to carry out the business operations in a way that is not restrictive, and creating those additional obligations, such as the 3-strike policy that you mentioned, makes it very challenging when it comes to things like performance management. So it's important to get these things right, and that's why we include it as part of our workplace relations review. So when it comes to workplace compliance, if you fall short of your obligations, one of the things that we're very cognizant of is it may not even impact you or your business in the short term. So often we're told by clients that they really never had a problem with a disgruntled employee or any contact or audits from the Fair Work Ombudsman. So when considering a workplace relations review, I think it's really easy to see why some businesses will take the attitude of, if it ain't broke, don't fix it. So what would you say to a business who's never had a call or an email from the Ombudsman or a challenging employee dispute?
Well, that's where the term the rainy day policies sort of do come in place. If a business hasn't got policies and procedures in which it operates under, they could be setting unfair precedences from case A to case B. They could manage with their first issue, just winging it through the process, maybe getting it right, maybe getting close to the point, but then they could get to the second process and do it completely different. That second case actually then has a contest for procedural fairness about, well, how come person A got treated differently to person B? Did a business have policies in place and therefore did they follow them? Which is that common point of procedural fairness. A good handbook is to set the scenes of what an employee should be and how that good employee should be operating, and keeping it down to the basics of the pieces for the Fair Work Act. If a business then wants to go into how to do manuals or operation manuals, how to do your job or your position descriptions, then they should be kept different again from the policy manual in a separate operations manual, separate job descriptions. And again, all of these outside of the contract, because business needs to change, business needs to evolve, and businesses should review their policies yearly, especially in consultation with their employees. There was one case that I did go through with a client where they'd done everything by their policy, they'd implemented their policy, they told their employees when they first started, but 3 years later they had a sexual harassment case. The business was found partly liable at the end because, yes, it had the policies in place, but they hadn't refreshed their employees' knowledge on the policy. It was implemented 3 years ago. A lot of the staff had been there a lot longer than that policy, and there was no sort of rework or modern reviews of that. So the business could have done more in its powers to prevent that from happening if they did a couple of workshops or revisions throughout the year, at least once a year, on their policies and procedures in toolbox talks and things like that. So having policies is that protection piece that a business can go through challenges when it hits them, as well as ensure consistency throughout their procedures, and again, ensure that they're meeting their workplace obligations as best as possible.
Yeah, I think the other piece on that is when it comes to more the compliance side, so moving away from the policies and procedures, when it comes to minimum rates, when it comes to award coverage, etc. I think that even if you don't do the work right now and you haven't had a call from the Fair Work Ombudsman, when there is a call from the Fair Work Ombudsman and you've got it wrong, the issue or the amount that you're may potentially be liable for compounds. I think there's a 6-year liability period. Is that right?
Statute of Limitations is for up to 6 years. Basically, the powers on which the Ombudsman can investigate an underpayment of claim for the underpayment claim for the employee. And if you navigate that or manage that yourself, well, an employee could technically ask you to look at 10 years if you were to do that internally. But if it went through to the Ombudsman, there would be then the statute on the 6 years. So it's really important that, okay, well, you've got things in place and you may think things are sound for now, but have they always been sound, and are they always, or are they going to remain sound with the changes? The national minimum wage went up the highest it's ever gone up in the last 12 years, from the Fair Work Act. And we're probably going to look at another big increase next year. Not as big as the 5.2 for the lower sectors of the wages and 4.6 in the awards, but it still might be quite another big one. So if people are above award, or if they're on wrong classifications, or if they're under the wrong award, these salaries that people are getting may come under fire and may be a lot closer to being on minimum wage than you think they are.
And I think the point really to drive home here is not only the 6-year statute of limitations that Jason just covered, but if you make a wrong assessment regarding a pay rate or award classification, not only can the Ombudsman go back 6 years, but multiply that by 5, 10, 15, 20 employees, however many employees are impacted by this assessment. It really, drives home to me the importance of this workplace relations review. It's better to do the hard work up front rather than face the compounded or potential compounded ramifications at a later date. So I think this really helps what we've just discussed, businesses of all shapes and sizes, to understand why, for most members, our workplace relations review and structural implementation is, in our opinion, an essential first step to really set the foundation for all future advice that we can provide. But to switch gears, for businesses who have decided that they need to review their workplace relations affairs and they want to undertake a workplace relations review, I'm hoping that you might be able to share some insights as to what to expect from the process. So Typically, we begin with a kickoff meeting to get a high level of understanding of the businesses and its current structures that it has in place. Do you want to share what's typically discussed during the kickoff meeting?
It's pretty much a get to know each other type of a meeting. Myself building rapport with the client, trying to understand exactly what they do, how they do it, who they do it with, and what are their employees assisting them in. The workplace relation review is obviously just what we do at the beginning of the relationship with an employee, but it's this information that we gain, it's this level of understanding and trust that we build within each other that actually sets better HR practices up for in the future. Every time I go through a national minimum wage increase, I'm always reviewing the previous workplace relations review information, so I can give them more detailed so what information. Like, okay, yes, the award's gone up, but I noticed that these class of employees on our last review were pretty close. So again, we may need to look more specifically at these wages in the future. So that kickoff meeting is about them getting to know exactly what the HR workplace relation review process is going to undertake. It's me getting to know the feel of what their business is and how they do their business. And it's a good kickoff session before then breaking the ice on getting into the data. After the welcome meeting, so to say, I do crack out my spreadsheets, get into understanding a lot of detailed information about how their wages and their structures are with their employees, and go through a benchmarking exercise just to ensure there's no risk of being under the wrong award or the wrong classifications, or missing penalties, allowances and loadings, or travel allowance that needs to be paid to the individual. And that's why the workplace relations review is so good. Within that kickoff meeting, within that spreadsheet process that I go through, or any additional questions that I ask at the on stage of that, it's about gaining that understanding of the business so we can provide that future advice, not just the advice for drafting contracts and policies and checking over wages at the beginning.
All right, so now let's fast forward a little bit. So we've had a kickoff meeting, we've filled out our spreadsheets, we've collected all the relevant information from the business. From a client's perspective from here, I think most of their hard work is done by collating this data and providing this information to us. And from an on-demand HR perspective, our hard work behind the scenes is really just starting. So what do you do with all of this information?
Well, as I said, I use the spreadsheet to help benchmark all the wages against the awards, making sure that there's no risks in that sector of wages. I map out what type of contract that employee should get, and then I get into drafting the contracts that correspond to the different streams of employment for the employer, for our clients. We would draft the full-time, part-time, casual contracts, as everyone would be aware of, but we break those down even further into awards or streams or topics, types of employees, so that it's easier set of documents to work with. After we finish with the contracts, we also do the policies and procedures and any additional documents that a business may need, from health questionnaires and employee detail forms, certain transfer cover letters and things like that we produce from time to time. Basically, anything that a business would need for onboarding, that's what we deal with in the workplace relations review. If a client takes up an ongoing support package with us, well, yes, we've given you all these documents, but that support process is to help us, is to allow us to help you with the documents. Other than just giving you contract templates, we then go even further into itemizing these contracts, inserting employees' names and details and figures to basically give you a completed document for you to review. If the client likes that, then we go into an implementation stage with the employee. One of our best tools that a lot of our clients like at the moment is our electronic onboarding process, where I can put employee detail forms, tax, super, contracts and handbooks onto a digital platform for the employees to review, for them to sign, for them to get sent to the employer to sign, and then to be ready for download for applicable parties, or even sent to payroll directly for them to load into their systems. And that's a tool that has taken a lot of time off the client's hands and putting it into our system, so that we can, they can better spend their time on managing the business instead of being stuck down in admin work, which is what we can take care of.
So, question with that notice. Do you want to give me an example? One of the things that I think is important to understand is around your comments about the employee streams. So, do you want to maybe pick a type of business and give the viewers an example around some of the typical or common employee streams that you're producing in contracts? Because there's a little bit of different way to doing it than simply producing or thinking about producing an employment contract for every single employee that we have, even though that's the end result. Why do we put it into streams, and why does this make it easier? And give us an example.
Yeah, well, different segments of employees have different entitlements. Your frontline workers are usually paid on an hourly basis. Long-term employees, managers are paid on salary basis. So first and foremost, just the remuneration clauses are different. Employees can be entitled to cars, they can have phone packages and things like that. So I draft these specific clauses around those set arrangements. One of the other bigger breakups is that different awards have different termination clauses. They have annualized salary arrangements built into them. So I've got set clauses that deal with different circumstances within an award. Let's just go back to the IT industry. An IT professional who doesn't have a degree qualification is not covered by, in an IT business that is not covered by the Professional Employees Award. If I drafted one contract to just suit that business alone, you've got in Professional Employees Award a 1 month termination period notice, whereas in miscellaneous clerks or even award free, we only have to be managed by the National Employment Standard notice of 1 to 4 weeks. So your probationary clauses are different, your termination clauses are different, just because of a person's single attribute of having a degree in an IT science field. So when I draft different streams, I'm putting that context into place. Is there award quirks? Is it a personal quirk, or is it a business obligation that class of worker has a different set of contracts to what a different class of worker needs?
Fantastic. And just going back to an earlier comment that you made around the digital onboarding side, do you want to, obviously, each employee is different to some degree. It's the same but different. So you've itemized this across to the different employment streams. But for example, a client might want to give a particular employee, I don't know, a laptop or something as part of their package. So do you want to share a little bit about, from the client experience, how they, let's say they wanted to engage a new employee, once we've done the workplace relations review, what's involved from the client side to request us to produce a contract for them?
Yeah. So during the workplace review, we produce the contracts as templates. There's insert names, there's insert price values, choose optional sort of clauses that may apply. Now, the client has that contract, they could use that contract. But what we've created between me and Andrew is that we've made an online web form that basically clients have access to. They put in the key details of the person's details, email address, how they want to pay them into the form. And then I take that contract template, the way that they've answered some questions on the form that gets sent to me, and draft up a contract that's specifically suited to that person's circumstances. So you fill in a web link with the employee's details. I take the template, fill in all the details, and pretty much send you back a done contract. A client would review it, see if it's okay, come back to me with any questions, concerns, or changes. I make them, and then we go either give it to the client to issue, or we use our electronic onboarding software, where then we can manage that process, take care of all the middleman handover transfers, and ensure that the documents are reviewed, signed by the correct parties, and then issued to the people that need to have them.
Fantastic. So moving down the process, we've now completed the workplace relations review. The clients approved all the contracts, the policies, procedures. One of the questions we normally get up front is, how long does this whole process take normally? And what's the next steps for the client?
So the process length is like, how long is a piece of string? Businesses' needs are different. Businesses' sizes are different. I could, if I was directly working with a business and had their attention for a full day, do everything over and done with in a day. But would the client see value in just having me out there for a day, or would the client see more value in working with this process over time? Typically, we are waiting upon the client for more information. We're waiting upon them to review the documents. We're waiting for them to approve or get certain pieces of data or information for us, because we try to be proactive as much as we can. We advise the clients in the welcome meeting what sort of timeline we expect on this project. It could be a day, it could be a few days, it could be a progression over time. It all comes down into, as well as, once the client has the information and data, the documents, how do they want to implement it? Are they looking at a deadline like a July turnaround with new wage rollouts? So we're under pressure if this was back in June, or are we looking at now that we're going through more of a relaxed revision or review approach with the business's demand? So when it comes down to time bases, we can meet the client's deadlines as much as possible. But again, when it comes down to drafting, I could spend just one day or a few hours on getting all the award information down pat, drafting contracts and handbooks and breaking them out into streams. It's my day-to-day job. I can pump them out quite quick, but if I'm in consultation with the client and talking about things that are very specific, I do like to spend the time on them sometimes to be able to draft out a clause that's more specific to them and not just take something off the shelf.
And I think the really important point here is that you mentioned, typically we're waiting on the client, not the client waiting on us. You know, if required, we can punch out a workplace relations review relatively quickly. But typically, obviously, from a client perspective, there's a lot of other competing business priorities, which makes things like producing reports on employees' wages and all the other bits of tidbits of information that we need, looking at their current employment contracts, all those sorts of things can take some time to produce for us so we can do our job effectively. And I think the other point that you mentioned is sometimes a little bit challenging when it comes to the rollout stage of the documents. And so we've had experience in the past where employees are skeptical when, for example, a new employment agreement is rolled out. It's like, well, what are you taking on for me? Why do I need to sign a new employment contract? All these sorts of things. So when it comes to rollout and implementation, I think it's very important to be strategic for that and come up with a strategy, whether it be, hey, initially we'll start out by just rolling this out to new employees and wait for the next pay increase before we roll it out to our current employees, whatever it may be for that business. And one of the things I think when it comes to the workplace relations review, for us, yes, it's our first initial kickoff project. And we have some clients that come to us just for the workplace relations review. But in reality, the implementation of the workplace relations review tends to be complemented, in my view, around the essential support package, which is our other typical engagement that we have, which allows us to support the client throughout the process, as well as assisting them with their day-to-day advice. And this really makes both our clients and our jobs, to be honest with you, a lot easier, because that day-to-day advice is based on a solid compliance foundation, which is the whole purpose of the workplace relations review. I think we've covered a lot of this in significant detail. Is there anything that you would like to add, or anything that you think that we've missed when it comes to the workplace relations review?
I think out of my experience of being in this space for the last 5 years directly, and in HR for a good decade now, the most common thing that I've seen when it comes down to a workplace relations review is that businesses have competing priorities. They have other operation pieces on their agenda, or don't have the right amount of staff to be able to roll this process out efficiently. We've got some big businesses with over 100 clients, and other businesses with just a handful of clients, a handful of employees, I should say. And one of the common things I've seen in the last 5 years is that I've gone through these processes with businesses, or we've been affiliated with certain other businesses, and they haven't necessarily taken action with the workplace review. Unfortunately, things come to a crunch in that business, and if they'd rolled out their contracts, their procedures or policies, that next issue that they come back to us with could have been easily ironed out with having that framework in place in the beginning. And that's why I find the support so important for the business. It's okay, I've done all this work. I don't want to just dump it on your doorstep and say, okay, this is what your next step should be. Workplace relations review is over. Good luck. I'd rather work with the business. Okay, I've done all this hard work with you. Employees are tricky. Some employees are going to work with the business. Some employees are just not going to play ball. And it's then that insight of then, okay, well, I've done all these changes for you. I know how all this works. Now I can help sell it to the employees. I can help you sell it to the employees, or we can go through an electronic signing process to make sure all the employees are updated with it. So I think just at least that initial 3 months after the review is then that implementation stage. And that's why our support services is so vital in that stage. It's helping roll out and helping deal with the issues that could come out of that process. Business could just implement it for the new employees, but again, you've got then double standards for your old employees. So whether it be just rolling out the contracts or their handbook alone to the employees could be a different strategy we could employ to be able to help that part of the business out. So going through the workplace review, we've gotten a lot of things corrected, a lot of good things in place, and I just want to see businesses start to utilize that effectively so that their rainy day issues are simple issues, not complex cases before the Fair Work Commission or Fair Work Ombudsman, so to say.
I think that's a really good way to wrap up the session today on the on-demand HR workplace relations review and structural implementation. For those that have watched the whole way through, I've got no doubt that you all would have gained a lot of insight as to why this process is so essential and what you should be expecting should you engage on-demand HR to carry out a review for your business. And obviously, we've got Jason to thanks very much for this, to share his experience with our broader audience. So really appreciate your time, Jason. Thank you very much.
Thank you.
We understand that many businesses out there are really not of the mindset of being proactive when it comes to their HR and workplace relations affairs. So if your business is facing an immediate or urgent HR issue and you'd like to have a free and no obligation chat with one of our team, please keep watching for details on our free HR strategy session. So thank you very much for watching. We'll see you all next week, and we have an exciting one planned for next week where we're going to be chatting with Stephanie Joseph about carrying out an effective recruitment campaign, which I think would be an excellent session. At 3.5% unemployment, it's certainly a topic that's on a lot of businesses' minds and something that we're asked to speak about quite regularly. So looking forward to sharing that with you all next week.
Does your business currently have a HR or workplace relations issue?
Are you unsure how to work through compliance issues but still achieve a good business outcome?
Why not take advantage of On-Demand HR's free 30-minute online consultation with an experienced HR consultant?
At the end of the consultation, we also provide you with a strategic action plan to resolve your current issues.
To see the types of matters we can help with and to schedule your consultation, please visit ondemandhr.com.au/advice.
We look forward to delivering certainty, confidence, and clarity for your business in your HR and workplace relations affairs.